Hi, it's Ron again. Thanks for joining me. Welcome to lesson 3 of our law learning extravaganza here on whatever platform you've chosen. And I hope you chose wisely. Today I want to identify, target, and destroy the elephant in the room. That's right. I'm talking about criminal law. I have always made it clear that I'm not going to talk about criminal law. I'm not going to talk about it because I don't have all that much to say. Oh, there are some similarities between the civil litigation that I work in and criminal law, but you're entitled to genuine, I don't want to say expertise. I can get in trouble as a lawyer for describing myself as an expert. You can describe me as an expert, but I can't describe me as an expert. Anyway, I don't know that much about it. If you ever hear me talk about a criminal law issue or comment on a criminal law case or jump in on a criminal law live stream or something, it's because I do know enough about how trials are conducted, about the rules of evidence, about the black box that is a jury, to have something fairly intelligent to say. So let's talk about the difference. Civil litigation is between private parties. The government can and frequently is involved in civil litigation, but in criminal litigation, the government is always involved. Criminal litigation is prosecution by the government in the name of the people. And you'll often see in some states, for example, in California, the people of the state of California versus Jones. That's because the state is presumed to be acting on behalf of the people when it prosecutes someone for a crime. In a criminal case, it's the people against the defendant. In a civil case, it's people against other people or companies against other companies. It always involves some kind of person. When you see the word person in legal contexts, keep in mind that can and almost always does include corporations or partnerships, LLCs, companies, nature, such as we are. Not a creature of the state. These other entities, of course, are created by the law. They're created by the state, not by God. Parties are different. People, companies, natural and unnatural, but not necessarily the government. The government can be involved in civil litigation. They can sue over breaches of contract, and they do all kinds of law enforcement that is civil enforcement without being criminal enforcement. No one's going to go to jail, for example. We'll talk about that piece of it in a second. Civil and criminal litigation both involve different burdens of proof. So in civil litigation, the burden of proof on the claimant, usually called the plaintiff, is the preponderance of the evidence, which means we'll talk about the difference between jury trials and bench trials in a later chapter. The fact finder is I am obligated to prove my case, all the elements of my case, by a preponderance of the evidence, more likely than not. Not so in a criminal case. In a criminal case, the state has to prove its case beyond a reasonable doubt. You say to me, Ron, you're just giving me a lot of words here. More likely, reasonable. That's all we have. We're human beings. The application of these words that the recipe is made. That's how we do it. In any event, it's a much higher burden of proof in a criminal case than in a civil case. Now, in civil litigation, what's the purpose? You're trying to resolve a dispute between companies, individuals and companies over a breach of contract or the commission of a tort. A tort is a non-contractual legal wrong done by one party to another party in a civil context, meaning not a legal wrong like I punch you in the nose. That could be a tort also, actually. We'll talk about that in a second. Criminal litigation, we are trying to determine whether the defendant committed a crime of which he is accused. If he violated the law and the jury finds that he violated the law, he's convicted, and we uphold the law, we maintain public order, we probably advance some prosecutor's career, and very likely in our time we visit political revenge on our enemies. That's the world we're living in today. So in civil cases, where there's a dispute between two sides, two human sides or two corporate sides, maybe even the government side, the idea is to put matters right. There can be an award of money, there can be an injunction, which is an order by a court to do something or to not do something, or merely to declare something, that something has or has not happened, or that something is or isn't legal or illegal, or to challenge a law. The plaintiff is seeking some form of compensation or relief for the harm he has suffered. And when I say the plaintiff in these examples, that can also include a counterclaim plaintiff. In other words, a defendant who countersues. That's a term you hear all the time. It's not really an exact or precise legal term, but essentially, you're suing me. I'm suing you back because actually I wasn't going to sue you. But now that you sued me, let me show you a thing or two. You're the one who owes me money. You're the one who stepped on my toe. So when that happens, the defendant stands in the shoes of the plaintiff, keeping it really simple for now. In criminal law, there's no such thing as a counterclaim. There are no countersuits. For all practical purposes, prosecutors can and do whatever they want with virtually no accountability whatsoever for their actions, including the most vicious and unjustified abuses of their power. If someone is convicted of a crime, he might pay a fine, he might go to prison, he might have to do community service, he might get the death penalty. Oh, yeah, we still have that. We still have that. But the purpose in a criminal case is to punish and deter and advance your career and destroy your enemies. Now, I mentioned before that if you punch somebody in the nose, that can be a criminal case and that can be a civil case. And it can be both. The crime of battery, well, you know the difference between assault and battery, right? I assault you, I assault you when I place you in fear of imminent bodily harm. I batter you when I touch you without permission. Assault and battery, they often come together. Love and marriage, love and marriage, right? Okay. The police may or may not press charges. Oh, we'll talk about prosecutorial discretion. I don't know when, because I said I'm not going to talk about criminal law after today, but it's kind of hard not to talk about the abuse of prosecutorial discretion, which is one of my favorite topics in the world. Okay. But even if you're not prosecuted, I can sue you for punching me in the nose. Oh, yeah. And guess what? I don't have to prove beyond a reasonable doubt that you punched me in the nose and caused me harm and how much harm it caused me. I only have to prove that by a preponderance of the evidence. What's the best known case of civil and criminal charges acting in parallel and coming out quite differently? You know the answer. It's the O.J. Simpson murder case. You remember, of course, when the famous former football player and lightweight actor O.J. Simpson killed his ex-wife, called Brown Simpson, and her man friend, Ronald Goldman. Goldman. He killed him because he was a jealous psycho. And he got away with it. He got away with it. The prosecutors were inept. The judge was a starstruck incompetent, and they got away with it. And he got away with it. But OJ was a turning point, in my humble opinion. So he got away with murder, literally. But what he didn't get away with, wrongful death. The Goldman estate sued him for wrongful death, for causing unlawfully the death of Nicole Brown Simpson. And they won. Why the difference? Probably the quality of the lawyering was different. I don't recall that the lawyers prosecuting OJ were particularly good. I do caution people against armchair quarterbacking of what lawyers do. You don't have the red welt. It's an old fashioned legal file of paper. If you don't have the red welt, you don't really know what happened in the case. Fine, fine. The biggest difference, though, is that in a civil case, you can do something that you can't do in a criminal case, which is you can call the defendant to the stand and he has to testify whether he wants to or not. In a criminal case, because of the Fifth Amendment to the United States Constitution, you can't call a criminal defendant to the stand. You cannot compel his testimony. You can't even say to the jury, isn't it interesting that Mr. Simpson has no testimony to offer about what he was doing that day, why there was blood all over his car, etc. You can't suggest to the jury that they should infer from the defendant's silence guilt. You pretty much can do that in a civil case, but you don't have to because he's going on the stand. And if he's already been tried in the criminal case, he cannot assert the Fifth Amendment and refuse to answer questions that are put to him under oath. You can take advantage of his very, very unfavorable evidentiary record and his obvious psychotic personality. Oh, I think so. Oh, I think so. And convince people that he killed those two people, which he did. And he was found liable. He wasn't convicted. In a civil case, you're found liable. In a criminal case, you're found guilty. Or, no, you know where I'm going with this. Not innocent. We don't use the term innocent. Who among us is innocent? No. We find the defendant not guilty. Prosecutor, you didn't meet your obligation to prove all the elements of the crime beyond a reasonable doubt. Therefore, we find the defendant not guilty. That's how it works. Liable for wrongful death, that we can do. Different jury, different lawyers, but a fine illustration of the difference between criminal and civil litigation. And I think that will be a nice way to end our third lesson. Thanks for joining me. Tell everyone to subscribe. And if they won't listen to you, kill them.